Hello, today we will consider how the reasonableness defence works when there has been an infringement of an author's moral rights. The defence provides that there will be no infringement of recognised moral rights where the conduct is regarded by the court as reasonable in all of the circumstances. To understand this defence in more detail, we will need to consider the three following points. 1. Which moral rights does the reasonableness defence apply to? 2. How does the defence work? 3. Why does the defence exist and what are its practical effects? First, we must consider which moral rights the defence applies to. In order to do this, we need to first understand what moral rights are. So, what are moral rights? Moral rights are authors' rights which exist separately from copyright and the other economic rights of authors. Although moral rights are different from copyright, they are recognised under the Copyright Act, and so is the defence. Moral rights are held by the author of a work, regardless of whether other rights are held by someone else. This emphasis on the creator of a work is due to the special relationship of personal effort between an author and the work. There are several types of moral rights, however the reasonableness defence only applies to the right of attribution and the right of integrity. Authors' and performers' rights are covered by the defence. We will collectively refer to these as creators' rights. The right of attribution is the right for a creator to be recognised as the creator of their work. The right of integrity enables a creator to protect their work from derogatory treatment. These are the rights the defence applies to. We can now consider how the defence works. As a defence, reasonableness must be established by the defendant in the infringement proceedings. If established, it will mean that the plaintiff's infringement proceedings will fail and no remedy will be available. In order for the defence to apply, the defendant must satisfy the relevant test. The test depends on which moral right the plaintiff alleges has been infringed. For an alleged infringement of the right of attribution, the relevant test is whether it was reasonable in all of the circumstances for the defendant not to identify the creator when doing an attributable act. An attributable act is defined widely and differs depending on the nature of the work or performance to be attributed. For the right of integrity, it must be established that it was reasonable for the defendant to subject the creator's work to derogatory treatment. In determining whether the defendant's conduct was reasonable in the circumstances, the court may have regard to a number of factors recognised under the Copyright Act. These factors are separated based on the moral rights infringed, and whether the right is an author's right, performer's right, or right in relation to a film. With respect to the use of a work, performance or film, the reasonableness factors include its manner, purpose, and context, as well as current industry practices. In McClelland and Serving International Holdings Proprietary Limited in 2013, it was suggested that the plaintiff must provide enough information in their infringement pleadings to enable the defendant to address the factors relevant to the reasonableness defence. An example of the use of the factors can be seen in the case Corby and Allen Unwin Proprietary Limited in 2013 regarding the unacknowledged use of photographs in a book. In this case, the defendant's claims that it was industry practice not to acknowledge photographs failed, particularly since the court held that it would not have been difficult to acknowledge the photographs. We can see that the reasonableness defence reduces the ability of an author to assert their moral rights. We will now turn to the question of why the defence exists and its practical effect. The policy underlying the defence is to prevent creators from asserting their moral rights in a way that is oppressive to those who hold other rights in the work. Over the line of reasonableness, the moral rights of creators are not protected. However, it is difficult to evaluate the effectiveness of the reasonableness defence as it is rarely used. Moral right infringement cases are also uncommon, and this could suggest that the defence is deterring actions being commenced, possibly due to their significant expense. This raises the question whether the defence is too broad and undermines the protection offered by moral rights. And it is this key policy question that we will leave you with.